Thanks, everyone, for joining us. As I said earlier, my name is Ryan Owens. I'm the director of the Tommy Thompson Center. I want to thank everybody for being here in attendance and thank our attendees, the panelists, our moderator. This is going to be a really interesting topic. I think we all know that digital security and privacy is incredibly important these days as we move towards a more online workforce, schooling. The online component, the digital component of things has become incredibly important. I've spoken recently to district attorneys across the state of Wisconsin as well. And one of the things they all point out is just the increasing prevalence of problems associated with online and digital platforms. And so I think this is a timely topic, particularly in the COVID era. And so we're really pleased to have this discussion and have such a great lineup. So before we begin, of course, as always, I want to thank the staff of the Thompson Center, Eric Templis and Tia Westhoff, as usual, have done a fantastic job. I want to thank them for that. I also want to thank our co-sponsors. Particularly, we have the UW-Madison Jean Monnet Grants. The executive director is Elizabeth Covington. She's with us today, is having some microphone issues, but she's a sponsor of this. She's doing a great job. We really, really appreciate her co-sponsorship and thank her for being here. We also have the UW Stout Cybersecurity Research and Outreach Center, and Holly Yuan is here with us today. We appreciate your co-sponsorship. Brian Dennis is the director of the UW Whitewater Cybersecurity Center for Business. He's done extensive work in the physical and cyber sides of business interruptions. We're excited that he's with us today and excited that he will be moderating the discussion. So it's time for me now to hand off. I want to thank you all for being here. Again, thank you to our panelists. This is going to be a great conversation. So with that, I will turn it over to Brian.
Thank you, Ryan. So hello and good afternoon. Welcome to today's panel. To whom should Wisconsinites look to advance digital privacy and security? As Ryan said, my name is Brian Dennis. I'm the director of the Cybersecurity Center for Business at the University of Wisconsin-Whitewater. I'm really excited to be a part of this today because the group of folks that we have have such unique backgrounds, and I'm really excited. I think that our audience is going to get a lot out of it. I know that the questions that they have for each other and the questions that you guys have are going to be informative, and really looking forward to an excellent conversation. So a couple of quick housekeeping notes. Today's discussion is divided into two parts. For the first piece, we're actually going to have a chance for our panelists to speak. We're going to hear a little bit about their backgrounds and their areas of subject matter. And after each panelist speaks, I'm going to definitely open it up for our other panelists to have the opportunity to ask questions. So often we'll do these types of collaborations and our panelists have just as good questions as our audience. And so I want to make sure that they have that option should they have anything that they're asking. Once we've gone through our panelists, we're going to open it up to a Q&A from our audience. And so you'll have the ability to ask questions then. I believe that we're going to use the Q&A concept within Zoom for asking questions, and I will moderate those questions as they come through. So joining me today are Rosalind Layton. She's a senior contributor on enterprise tech at Forbes.com. Some of her work actually includes Uniform Law Commission could resolve the state and federal impasse on internet privacy legislation. We were speaking to her earlier, and she says she does about 5 pieces a month for Forbes. And so I have a feeling that if you look her up, you'll find a lot of interesting pieces on this topic. Also with us is Gabe Maldoff. Gabe is an attorney at Covington and Burling, co-author of The Cost of Not Using Data, Balancing Privacy and the Perils of Inaction. We also have Olivier Sylvain. He's a professor of law at Fordham University Law School. He's also director of the McGannon Center on Communications Research and member of the Academic Advisory Board of the Open Markets Institute. Joining us as well is Omer Tene. He's the vice president and chief knowledge officer at the International Association of Privacy Professionals. He's also co-author of The Cost of Not Using Data, Balancing Privacy and the Perils of Inaction. Also joining us is my colleague, Dr. Holly Yuan. Holly is a professor and program director of the Cybersecurity Research and Outreach Center, CIROC, at the University of Wisconsin-Stout. Holly and I have gotten to know each other over the last couple of years, and I really love hearing what she has to say. So I'm going to go a little bit more into everybody's backgrounds, just so our audience knows exactly some of these experts that we really have with us today. So starting with Dr. Rosalind Layton, she is a visiting researcher at Aalborg University for Communication, Media, and Information Technologies, and a vice president at Strand Consult in Copenhagen, Denmark, where she is today. So we definitely want to thank Rosalind for joining us where it's this evening in Copenhagen. She uses evidence-based methods to analyze policy for the information, communications, and digital technology industries. She is a senior contributor to Forbes. Dr. Layton has a PhD in business economics from Aalborg University, an MBA from the Rotterdam School of Management in the Netherlands, and a BA in international service from American University. Gabe Maldoff is an associate in the privacy and cybersecurity group at Covington Burling LLP in DC. That's where he advises global clients on privacy, data protection, and technology law issues. Before joining Covington, Gabe served as a Weston Fellow at the International Association of Privacy Professionals and worked in a top-ranked European privacy law firm in London. Dr. Olivier Sylvain is a professor of law at Fordham University. His research is in communications law and policy. His most recent popular writing, scholarship, and public speaking engagements are on liability under the Communications Decency Act and the social impacts of artificial intelligence, which I find fascinating. At Fordham, he is also the director of the McGannon Center for Public Communications Research, the academic director of the Center for Law and Information Policy, and a research affiliate at the Center on Race, Law, and Justice. Dr. Sylvain holds a bachelor's from Williams College, a JD from Georgetown University, and a PhD from Columbia University. Omer Tene is joining us today. He is the Vice President of Chief Knowledge Officer at the International Association of Privacy Professionals. He is an affiliate scholar at the Stanford Center for Internet and Society and a senior fellow at the Future of Privacy Forum. Dr. Holly Yuan has led many successful cybersecurity research projects over the past decade in collaboration with the IT industry and her students. She has co-authored multiple book chapters and conference papers on cybersecurity with her peers and students all over the years. Dr. Yuan has won multiple Department of Defense and NASA cybersecurity awards. She's collaborated with the National Security Agency and Department of Defense and has successfully placed, and this is one of the things I love, 100% of UW Stouts Department of Defense cybersecurity scholarship recipients with full-time employment in cybersecurity. Dr. Yuan is currently serving as the director of the Cybersecurity Research and Outreach Center. So I'm going to spend a real quick minute just kind of setting the topic for today so you can really know what to expect. So cybersecurity is a challenge under the best of circumstances. But 2020 is a whole new world for us. The right to digital privacy and security has been put to the test as many of us work from home. As we look to the future, there are so many questions swirling around the topic of digital privacy and security. So let's start jumping right into it. Our panel of experts today is here to discuss just this. They will look at digital privacy and security from all angles and give advice to those working towards a secure environment. Let's get to start this topic rolling with our first speaker. So Rosalind, we're going to start with you. So tell us a little bit about your work.
Yes, so when I write for Forbes, I'm trying to take complex technology, regulatory issues and describe them for a business audience. So try to translate things that in everyday language that people can understand. When I'm at the university, I am teaching students who are going to become technology managers for their companies, CTOs. They will go into cybersecurity as well. So when I talk about this topic, I want to bring it from a policy perspective, geopolitical perspective, cultural, historical, and I'm going to leave the legal part to the lawyers. But I like to fill in some of the details that to help make it interesting for people who aren't always looking at things the way a lawyer would.
So it's definitely an interesting position that you're in right now, especially writing on this topic, which every day seems to not only change, but grow more important. The media frequently describes privacy in the US as the Wild West, which I see often, and GDPR of Europe as the gold standard. Is that a fair assessment, and why or why not?
Yeah, so I think that that's a great question. And, you know, it's one of the things that I would like to present for the students today of how to think about the European approach and the American approach, because they are very different in important ways, and also to understand the reasons why, and historically important. We can say that the American approach could be called the pragmatic approach. We are interested in what works. We were interested in law and action. The European approach, it comes out of the Enlightenment. We can call it the fundamentalist approach. This has to do with information and sort of basic principles, all information, people having the right to control the information about them. So this is very much embedded in the notion of human rights, or the European Charter of Fundamental Rights in the 1950s. And here, but what I think people need to know about the American approach, it goes back to the 1700s, and it was largely related to protecting people from the administrative state. So the way that privacy law emerged in the United States was very sector specific, with things like protecting people from the census takers or the post or the telegraph, meaning that they were concerned about the government surveilling them and their personal information. This is a different, Europe came into things much later. In the 20th century, the experience with the East German police and the Soviet Union, that really galvanized the idea about what is the role of privacy. So Europe is much later in its practice, and had developed quite a bit. But I would say in the United States today, we have literally hundreds of laws about privacy. We have a long amount of case law. So there's tremendous amounts of American privacy law. There's no such thing as there's not law. But what the American approach has been is to look at sector specific, what matters, what's important, what do people care about? You know, whether we have found out health information, financial information, information for children, and there's specific sector specific regulators associated with that, and that have grown up over decades, and there are companies that will specialize in that. Whereas the European approach is, you know, one data privacy regulator for everything. Now, you might say the downside from the European approach is that the compliance or the enforcement is much less than the US. Going back to the notion of pragmatism, it's very important in America that we see the privacy laws, that people comply, that they're implemented, that people follow them. And if you don't, there'll be very high penalty. In the European Union, it's very aspirational. So the compliance is relatively low. It's large to medium-sized companies that are there. And the enforcement is limited because the funds for the data protection authorities are limited. So for example, you know, any data protection authority in the United States would have a smaller budget than an federal agency in the US. So there's a lot less money spent or appropriated from the legislature to do this. It's quite different in the US because the sector specific regulators are quite powerful, and they're working also at the state level.
So what are the key features of US privacy law in practice? And specifically, What are the pros and cons of those?
Right. Well, I think when we look at the U.S. Approach, we would call it the risk-based or trust-based, as opposed to the EU, which we call command and control. In the risk-based idea, where we have a mutual interest between the party collecting the information and the person sharing the information. So again, where we would see is this has been important in the sense that we want to promote enterprise. We wanted to encourage beneficial uses of information, and also to say, you know, in many respects, permissionless information. That has been very important if we look at the growth of the technology industries in the United States, which, you know, the United States comprises 1/3 of the world's information technology. It's a staggering amount. The interesting thing I would say, you know, when part of my work and my research, I'm studying the outcome of policy and how it's implemented, that the European policymakers had expected that their rules were going to, you know, level the playing field, if you will, or create lots of new European enterprises. And after a successive privacy regulation, that hasn't happened in the European Union. In fact, the largest American technology companies are even bigger today in their market share than they were 2 years ago when the GDPR was first implemented. So that is not the outcome. Now, regulatory economists like myself, we understand that, because whenever you create something like GDPR, which is very expensive to implement, it costs companies between $1 and $3 million, maybe more. That becomes a barrier to entry. So it's a gift to large companies who can afford to comply with lots of rules. It becomes a barrier to entry to small and medium-sized companies. So what the European Union was about was to try to promote enterprise, a common market. What's sad today is we don't see new businesses forming. We don't see the small businesses growing into the medium and large enterprises, which we had hoped. And actually, this is something that American policymakers are grappling with today, the concerns in California, for example, with adoption of CCPA, that this is going to fall the hardest on 99% of the enterprises in California, which have less than 500 people. That means, can they afford $100,000 to $1 million to implement all the requirements, the software requirements, the auditor that you have to have on staff, the privacy officer you have to have on staff, the law firms you need to hire, all of the work that you need to do. And then what's the associated benefits with that, and to whom do the benefits accrue? So that is, something that we're, certainly concerned about. That is animating the discussion, certainly in the COVID world where economy is depressed. Where is the, are we going to depress the companies even more with even more regulation? So, but what I would say is, just to sum up difference between US and Europe, was that there's also the geopolitical aspect. At the time, the US wanted to move on its, national privacy legislation. Then the Snowden revelations came forth, and the United States sort of stepped out of the picture, and then Europe stepped in. So they took this opportunity to kind of set the global standard, and the US was not involved. This was going back in 2012 or 2013. So this was important for Europe from a geopolitical perspective, because they want to be known. If they're not going to make the companies that make the IT, they at least want to control the regulation. And so from that perspective, it's been successful. It has not been successful in terms of supporting the homegrown European enterprises that they expected they would achieve through this policy.
So I have a quick question, and I'm going to open it up to our panelists after this for any questions they might have of you. What are the local governments on the ground in Europe doing to assist people with GDPR? So I think here in Wisconsin, we're currently running a program on campus to help our businesses in the DoD supply chain. So this new cybersecurity maturity model certification CMMC is running through. And a lot of our suppliers are nowhere near being prepared for this. And so the government has stepped in to assist them to get to that point of readiness. Are European governments individually stepping up, or are they really kind of leaving that up to the EU?
Well, shall I take a stab at it?
Yeah,
I mean,
that was my question for you. Yeah.
Oh, I beg your pardon. I just thought it was for the panelists. I'm so sorry. Well, to some, I would say the UK and Ireland, they are attempting to try to help. It's something that we actually do in the US, is standards building. For many cases, when you have new technology, how do you deal with it if you don't know the right regulation? Well, you do it in a bottom-up way. You work with you get the industry practitioners, you get the stakeholders together, and you develop standards. And this is something that is done, as companies know how to do. They can be certified. We have an international standards organization. We have all kinds of standards bodies, and where you can say, depending upon the area of information where you're working, what are the standards around how do we manage this information and what do we do? So that is in the interim. In fact, especially with emerging technologies, where you have a bottom-up standards-based approach to help address those issues. I also recommend safe harbors, and this is where you say, as a regulator, you don't presume that a company, whatever they're doing, is going to be wrong. And I think that's also a difference with GDPR. It assumes that the companies are going to be bad and hurting people, as opposed to saying, we know that you're going to attempt to work in a way. We'll have the presumption of innocence, or the presumption that you're going to work in a bona fide way, and we won't punish you if you didn't comply at number 42 of 145 requirements. So that again reflects the democratic preference in the United States to focus on enterprise, focus on entrepreneurship, focus on the right to try things, the right to use information in different ways. And but what I would say is, when you look at the EU, there is certainly, they're using risk-based process in what they enforce. And that is really one of the big takeaways, that the largest fine out of the European Union was $50 million on Google, but most fines are a few hundred euros, a few thousand euros is not very much. They haven't had that many enforcements, considering how large it's supposed to be. And that, I think, is an important takeaway because, Americans are saying, what works? I want to see law in action. I want to see these big penalties. And that is not what the GDPR is delivering. That's not what's happening in practice.
I think Omer has a question.
Yeah, well, not so much a question, but a couple of comments, reflections on what Roslyn just said. So first of all, I agree with Roslyn that the characterization, you started with that the US is the Wild West of privacy and Europe is the gold standard is inaccurate on many different levels. I'd say, first of all, to begin with, the US has a lot of privacy law. And if it's the Wild West, I think it's due to the difficulty that businesses experience trying to reconcile, many different layers of legislation and regulation, some coming from the federal level and some from the states. The US has, like Roslyn said, sector-specific federal privacy laws, FERPA for education, for students, HIPAA for healthcare, GLBA for financial, FICRA for credit reporting, COPPA for kids, and on it goes. There are, more than a dozen of these. At the same time, it has literally hundreds of state privacy laws, including the ones that Roslyn just mentioned, the comprehensive laws that have come out of California the past couple of years, CCPA and CPRA, which just passed as a ballot initiative a couple of weeks ago. Second, there is a large difference, and it's been, documented and described in literature between law in the books and law on the ground. And there has been a significant enforcement and compliance gap in Europe for many years. Europe has had a data protection directive going back to 1995, so 25 years ago. GDPR, of course, is only in place for a couple of years, but that was there already. And even preceding that, some of the main member states, Germany, France, and others, had data protection laws going back to the 70s, but very little enforcement and very little sort of strategic recognition of privacy and data protection as an issue that isn't just a compliance exercise, but rather something that drives business processes and elevates to the board. And in fact, the privacy profession started here in the US even without a regulatory mandate. It started in the late 1990s when mostly technology companies and some data intensive companies like DoubleClick, which was one of the large ad networks later bought by Google, Axiom, which was a large data broker, IBM and others, started appointing chief privacy officers, not because the law required them to do it, but because they realized that data is one of their primary assets, that it needs to be managed wisely and strategically, and that it also entails some business risks. Where I'd like to disagree partially with Roslyn is with the characterization of privacy regulation as a kind of a deadweight cost for businesses, which stifles economic activity and innovation. I think that's inaccurate. Privacy regulation really reflects the necessity in the market for businesses to obtain trust. And, people won't use technologies and won't use new products and services if they don't trust the providers, the companies that, the platforms. And privacy is a key aspect in establishing trust. So I think absent privacy regulation, and in the US, some areas still are unregulated. For example, the data brokerage industry and some of the ad tech, advertising technology space. Without it, it's very difficult to bring consumers on board. And one case in point, maybe you will talk a little more about COVID-19 later, is the lack of acceptance and adoption of contact tracing technologies in the US. One reason is that it's a kind of a muddled regulatory area. People don't know what the rules are, and people are concerned about sharing their precise geolocation information, especially in a context as sensitive as pandemic mitigation. Think about your, Thanksgiving dinner next week. You want to share that with the government if they don't know that there are boundaries around what the data could or couldn't be used for.
So Rosalind, what are your thoughts on
Yes,
Omer's
well, so I'm delighted that Omer is here, and also, I'm I'm very impressed with the work of IAPP. I think they do a great job for their members, but also for laypersons who want to understand. They have very helpful explanations of the privacy laws. I would certainly agree that we're in a stage in the development of the United States where we realize that internet information is important, that we need a framework to regulate it, if you will. We need a way to manage it. The critique, I would say, in terms of the cost of privacy regulation, and that is where, as an economist, as an evidence-based scholar, we would look at, for example, cost-benefit analysis. California's Department of Justice issued a cost-benefit analysis preliminary for the cost of CCPA, where the costs are between $65 billion, almost $70 billion, and the proposed benefits, again, they didn't have great measures, that they were only about $5 million. So it's a tremendous cost on almost 2% of GDP of the state, with a very little measurable benefit. Now, maybe you can find a better measure, but the other critique of that is that most of the costs of the compliance are going to law firms. And we do know that there is an industry in the United States to hire lawyers, to hire software that is certified by lawyers, to hire legal solutions. So for myself, who's an innovation advocate, I would say, well, should your company spend $100,000 on lawyers or $100,000 on new R&D, a new molecule, a new solution in the factory floor, what have you? That amount of money is maybe more than the entire online ad budget for a firm. Now, again, we're not going to take away the, law firm is not going out of business at any time. I think that there's a balance. And the one other point to bring up here in terms of enforcement, if you look at the Cambridge Analytica settlement with Facebook for Cambridge Analytica, $5 billion and a major amount of conduct relief where the FTC can go in and, it has a tremendous ability to review what's going on at Facebook in terms of their privacy practices. That is 20 times what Facebook could presumably get in European Union for GDPR violation. So I think that's even without any new privacy laws. So there is, this is one of the, I'm glad we can have this discussion, because I think that the way the media describes what has gone on with Europe, they like to use this language that is the gold standard. And I think, factually it is not. But I will say geopolitically, Europe has succeeded, for at least for the time being, to set the stage, because they moved into a space where there was a vacuum where the US wasn't.
Brian, I do want to just respond to this, and I don't want to belabor it, but just in a couple of sentences, because it's hard to argue about data and numbers when you're not actually looking at the research, at the paper, at the slide. But I have to say that these numbers sound completely unrealistic to me. There's no way that CCPA compliance costs 2% of California's GDP. It's just, even if there is research that says that, I would challenge it. CCPA is quite a limited law that applies to a limited number of companies. Even if you think, of companies having to expend, say, large companies having to expend a couple of $1 million on this, we're talking about companies that their kind of, annual turnover is hundreds of billions of dollars. So it doesn't add up. I also want to say that privacy compliance isn't just the realm of lawyers. There's nothing wrong with lawyers, and I love, laws that make work for law firms. Gabe used to work with me. I'm a lawyer myself, and I used to be a law professor. But having said that, the IPP, which is the Professional Association for Privacy Professionals, we have more than 60,000 members now, and only 30% of whom are lawyers. So the majority of people who manage and adopt privacy compliance measures are people who work in IT, engineers, just business management, and it's not necessarily just a law and compliance function.
I wondered if I could say.
Can I make one quick to follow up from that? Because again, I'm a huge, I read IAPP quite a lot. Has a great website. I'm not a member myself, but I do follow. But IAPP's membership doubled when the GDPR was promulgated. So it has been great for the law industry. There's no doubt about that. And there's certainly a need for that. The critique, of course, is that what the GDPR did was create new jobs for bureaucrats, for lawyers, for people to do these things. Just for the students who want to look this up, the references for the cost benefit analysis for California are published on the California Department of Justice website. They commissioned a economics firm in Berkeley, California, to prepare the analysis. If you go to Forbes, I have other analyses listed of the cost benefit of privacy, everywhere between I've seen 3 to 4, costs 3 to 4 times as high as the actual benefit. The problem here is measuring the benefits is difficult because in many cases it's an intangible benefit and we don't have great measures of privacy. But for people who are regulatory, a policy person such as myself, then you also want to be careful with the regulation you do when you don't have good measures to start with.
I think, Gabe, you had something to add?
Yeah, I don't feel particularly compelled to defend the lawyers out there, but I do think that having practiced both in the US and Europe, it might be useful to share what my experience was on that. I think the point that actually both of you made, that the US has a lot of law and that it comes from a lot of different angles, helps explain what we've observed in practice. And that's that there are real risks here. And some of the costs you're talking about getting legal advice and technology solutions result from the fact that information is more important to organizations than it was before. And the privacy risks to individuals of more information being out there are going up. And so law is going to, whether you have a GDPR-like law or you don't, law is going to find ways to try to limit the types of harms that we see when there's these risks out there. And the cost of not having comprehensive law in terms of what that requires of legal advice is often higher because you have to consider risks from the vantage point of a range of different frameworks, some of which haven't been applied to personal information in the past. And so from a practical perspective, I'd say actually the costs of legal advice for privacy are higher in the US because of the absence of comprehensive law.
Well, and I think this is a great pivot point. So Rosalind, thank you so much for your insight. It's definitely so intriguing to hear all of this. And so now let's chat with Gabe a little bit. So Gabe, tell us about your work that you're working on right now.
Sure. Well, so as I previewed already, I help organizations comply with the range of laws we see around the world that are growing in number, it seems, every week, or growing in complexity. And as personal data is becoming more important to organizations, it's becoming relevant as part of corporate transactions and antitrust investigations and new technology development and a whole range of different things. And we're
we're helping our clients navigate this increasingly complex space.
So, we have already started a conversation about the California Consumer Privacy Act. And so how does the CPA fit within the trend you described about privacy laws moving away from from notice and choice?
Sure. So Professor Tene and I wrote an article together a couple of years ago about chronicling the shift in the way policymakers and organizations and scholars are thinking about privacy, and how we hypothesized that how that shift might actually change the regulation of data from being something that's purely focused on privacy and locking data down to also unlocking benefits for other what are viewed as public goods. And so to answer your question, I have to go back to the beginning of time, if you'll indulge me for a moment. And the beginning of time in the information privacy world is the 1960s, when several scholars, including Alan Weston, are contemplating how to regulate information. And they propose what are called the fair information principles. And these become the bedrock for almost every information privacy law around the world. And what they require is, first, that individuals should be given notice about how their information will be used. There are a number of other principles, but central among those others is that they should have some form of choice over how that data is ultimately used. And we see this notice and choice framework become reflected in a number of laws like the European Directive, which Professor Tene referenced, and other US laws, including the Fair Credit Reporting Act here in the US, which dates back to 1970 and gives individuals an ability to understand when their information is used for credit reporting and to exercise some control over it. But fast forward to the last couple decades, as the growth of the consumer internet and technologies that involve personal data have made information a much more valuable resource in essence, and much more central to the digital and real economy. We've seen a shift in the way that personal information is regulated. That shift has gone from a model that's focused purely on giving people notice and choice and placing the onus on the individual to decide appropriate uses, to one that's much more holistic in assessment and that looks at limitations and fair limitations on the use of data. So we see that, for example, in the GDPR, which on the one hand has a very strong consent provision, which gives individuals very concrete control. But on the other hand, by making consent so difficult, it's also introduced this other valve for using data called the legitimate interest test, where organizations are permitted to use data, where on a balance of interests between the organizational and public needs versus an individual's privacy rights, the balance supports the use of data, then the organization can use it. And the GDPR sort of leans into this test and imposes accountability and risk assessment processes around it, which sort of shift the emphasis away from individual control towards public benefits. And I think you can place CCPA sort of at the intersection of two of these trends. So on the one hand, it's a notice and choice law. It gives individuals rights, consumers rights to understand how their information is used and to obtain a copy of it and to opt out of the sale of it. But on the other hand, it also includes broader requirements. So the sale requirement means that you have to have more accountability for supply chains of organizations with which data will be shared. And there are some use requirements. So the CCPA also incorporates a concept of data portability, which on the one hand protects privacy by giving people control over their information. So the idea behind portability is you get your data in a format that allows you to shift it between providers. But on the other hand, that also includes a nod towards other interests that might be implicated by data, like economic and competition benefits by unlocking data and making it available to more providers. And so portability not only emphasizes privacy, but also shows that we're starting to think about data in broader frameworks.
And so are there any models for how to effectively balance the competing interests that are really, we've got on the privacy side, the personal portability, along with this big tech. So are there any models out there on how we're going to effectively balance the competing interests that may arise?
I think we're seeing a number of creative responses for how to sort of unlock data and make it available for public use while also protecting privacy. One example I would point to is India has proposed a privacy bill, which is still in draft stage. And interestingly, it includes a right for the central government to compel the production of anonymized information for public policy benefits. There's a lot of discretion left in there. So that might not be necessarily a model that works for the protection of privacy. On the other hand, it leaves a role for the regulator to define what data is sufficiently anonymized. So if the regulator is able to exercise that function and incorporate the various interests of stakeholders when it defines that data, that might be one solution. I'd also point to another mechanism within the GDPR itself that I think has been underutilized but offers some promise. So the GDPR creates certain safe harbors from regulation where you abide by codes of conduct that are approved by regulators. And in order to have a code of conduct created and approved, it needs to clearly specify what the standards are going to be for the protection of privacy for a given industry. And that may include industries that share data amongst themselves. And those standards need to be created in consultation with stakeholders who will have a stake in what happens with their information or how they can use it. And it gives a role to regulators in checking the work and making sure that the ultimate standards do protect privacy and comply with the GDPR's principles. So we haven't seen codes of conduct approved yet, although there are initiatives to do so. And that sort of consultative model focused on specific use cases might be an interesting way to balance these interests while creating certainty and protections for individuals.
So I'd like to open it up to questions from our panelists, but I do want to kind of drag somebody in. I'd like to drag Olivier into our conversation with Gabe. Really coming from this consumer side, I'd like to hear your opinions on some of the work that Gabe's doing and maybe your take on it.
Thanks for bringing me in. I did have a question, but in the vein that you've framed this, I'm inclined to just wonder really about this Indian effort, which I hadn't heard about, and what I'm especially interested in hearing about is, Brian, I will come back to the consumer issue, but if you don't mind, I'm curious to hear about this Indian effort because it might help me answer or ask the question in that regard. So there are competing public regarding interests that would justify the collection of anonymized aggregated data, right? That's what I hear you saying. And I'm curious to know, what are policymakers in India thinking would be those public government purposes, right? I mean, obviously, the first thing that comes to mind, even if it's anonymized information, I think of efforts in the United States with regards to law enforcement, trying to collect information about, anonymized aggregated information about folks in any given platform. But I suspect that there are other things at work, and I'm asking in earnest, so what are the other competing government purposes?
So the way the bill frames the requirement is that this would be to enable the exploration of public policy for the digital economy. And it's really framed that broadly. And so I think you're right to raise these questions. having that sort of broad right without the right types of safeguards around that could be quite troubling. And I think the sort of the devil's in the detail here. It also gives a role for the regulator in defining how this provision will work. Of course, the regulator hasn't been created yet. And so we have really not much indication of how this would be exercised. It could end up being a massive loophole that permits the government quite broad access. Or if it accords appropriate, in my view, if it accords appropriate sort of involvement of stakeholders and participation, then it might be an interesting way to unlock the value of data while also creating safeguards around it.
Well, the reason, so to return to the question I think Brian was hoping I would ask with regards to consumers, I mean, I can envision some non-law enforcement related purposes but that remind me of debates in the United States with regards to the Computer Fraud and Abuse Act and you know, intermediaries and data brokers' use of user data. And what I mean by that is there are always interesting research purposes for finding out why a Facebook or a credit card company collects the information that they do and what they do with that information in the aggregate. You know, during a political season, we might want to know how advertisements are targeted to consumers, for example, in the aggregate, and it's kind of de-anonymous. So I could see why there are virtues here, and so on the consumer protection side, I can envision there being constructive reasons for it. But knowing something about how governments use data, and thinking particular in New York about something like Link NYC, which is this really forward-looking project to deploy, to transform public infrastructure, the telephone booths, the public booths, into these places where people can, you know, can browse the web and charge their phones, is actually, there's a kind of function creep where the government agencies that are relying on that data is really only the Department of the New York NYPD. So I'm just curious about that, wonder about it, although I do see great virtue potential in it.
Yeah, I agree with that. And that's why I raised the code of conduct example from the GDPR, because I think a model that takes the government out of it or reduces the role for the government and really puts the kind of direct beneficiaries at the table is in creating the standards, I think is probably a model that that better protects privacy. But of course, it takes time to develop those types of stakeholder engagements. And I think that's why we haven't seen a ton of them successfully rolled out yet. But I think your point about the research context is especially interesting. We are seeing the European Union is considering legislation around this as part of its Digital Services Act. They haven't released a draft yet, but there's talk about including some requirements for sharing data for research purposes from commercial actors. And we've certainly seen privacy regulators in Europe talk about how codes of conduct might be one of, for research, might be one of the places where we could see the most benefit.
Holly, I think you had a question.
Yes, thank you, Brian. Yeah, I have a question that opened up to all the panelists. You know, we talk about the GDPR. I want to say that principle of the GDPR and the privacy law also radiate beyond the EU and the United States. We talk about India. We also see the new privacy law emerge from other part of the country, Japan, South Korea. And believe it or not, even in China, actually, in 2019, a year after the GDPR published in EU, China published its first cybersecurity and data privacy law. Talk about China, you know, I am a Chinese American. I'm American, but I was born in China, grew up in China. So we don't have privacy, the word privacy in Chinese, Chinese characters, talk about 4 years ago, 5 years ago, you talk about privacy in China, nobody understand, but now in 2019, China published the cybersecurity and the data privacy law. They declare that they are not as strict as EU, but they say that they're stricter than United States. So just about 5 years, in a very short time, they progress very fast. So my first question is, what do you think about China's voice, influence on this data privacy for the rest of, in the future? My second question is relevant to nowadays what happened to COVID-19. So right now we are still in a lockdown phase in Wisconsin, but China already opened up all their business, back in April. With 1.4 billion people, they've been able to contain this coronavirus because they take extreme measures. Like if you go to take a bus or any public transportation, the people have to swipe a health card. It's almost like FID. If you have a green light, that means you're good. But if it has a red light, that means you either tested positive, you contact the person who tested positive. So then they put you in the hospital, quarantine you. So in that extreme measure, they've been able to, contain the coronavirus. So my second question is, we talk about the privacy versus the public interest. Under these special circumstances, pandemic, can American government or can any other government do similar things for, you think about the short term, long term, harm, benefits? So I want to hear your thoughts about this. That's my question, two questions.
Maybe I can start, Brian?
Sure.
So thank you for that, Holly. There was a lot in there, of course, because you're talking about kind of generally China's policy stance with respect to privacy and data protection, but then also the specific case of COVID-19 response. Let me start with the first part. I just think, we could devote an entire session just to one of these questions, never mind both of these questions. So starting, I think, at the top, it almost goes without saying that China exerts tremendous, influence on the globe generally. And this is politically, diplomatically, in terms of trade, economy, and notably technology. A lot of the large technological platforms these days are Chinese. And if you think of Huawei, which is the global leader for 5G technologies, if you think of Alibaba, Tencent, Ant Financial, which almost had, the largest IPO in history a couple of weeks ago. And interestingly, that was stopped by the Chinese government just 24 or 48 hours before the fact. So there's obviously a lot there. Now, China not only legislated the cybersecurity law a couple of years ago, it also tabled a data protection law, a privacy protection law just a few weeks ago, I think October 20th, if I recall correctly, and that law is now open to public consultation. So I think I find it interesting that China, even does that, like presents a law for a public consultation and certainly solicits views not just from the mainland, but also from around the globe, and I think is receiving a lot of opinions from around the globe. I think the driver for, I have to say, disclaimer first, I'm not a China expert at all, although I did learn Mandarin for 1 year in university. But in my mind, the main driver for China doing this now is exactly what I talked about earlier, the fact that privacy is key to trust and to market buy-in, because I think everybody realizes that if you look at Huawei, for example, there's like a whole trade and technology war around it all over the world. Of course, the US has, vehemently opposed any any Huawei deployment. Certainly it's not happening in the US, it's not allowed, but the US is also pushing Europe very hard to fend off Huawei as its communications infrastructure. And what's the reason for that? You know, cynics would say it's a trade war, the US wants its companies to succeed, but that's true in many different markets. I think the main reason for that is trusted computing, trusted telecommunications, and privacy. So, and then, you know, if you look at TikTok, for example, of course, hugely successful and lucrative social platform, especially perhaps here in the US, and yet raises significant privacy concerns, and this is kids' privacy. So there's a lot of, you know, there are a lot of issues there. And of course, the Trump administration at some point was saying that it would try to forbid TikTok from operating in the US. That sort of dissipated. But there is, you know, there is a valid, I think, issue and concern. So I think for China, certainly from the, you know, exporting technologies and exerting power in the global market, privacy has become one of the key vectors. And, you know, from my conversations with Chinese experts, I hear that there are similar concerns within China itself, that, you know, there are 1.4 billion consumers there, and companies want to succeed, and they'll succeed more if there is there are boundaries around privacy and what data could or couldn't be used for. Having said all that, I'll just add that China, and you can probably articulate this better than me, Holly, but China has a very different view of rule of law, you know, kind of at the top of the legislative pyramid than Western cultures. It's a different sort of perception and implementation of that concept of rule of law, and certainly a different view of privacy. Like Holly said, the word doesn't even exist in Chinese. China is a much more collectivist society, whereas, you know, the West is more atomized and individualized, and privacy, of course, does play into those social norms. So what China means when it talks about privacy might not translate directly to what we mean here in the US or in Europe, even if the laws look similar. Just to touch on the COVID-19 thing, that collectivist approach can be incredibly beneficial in some contexts. And I think COVID-19 is exactly one of those contexts. Like here in the US, we don't limit freedoms, and, you know, people are free to do what they want. They can wear a mask, not wear a mask, they can test or not test, and they can have Thanksgiving dinner with their families, even if, you know, their parents or grandparents are elderly and high risk. China, of course, takes a very different approach. Some would say heavy-handed, limiting freedoms. Yes, but the results are also you know, completely obliterated the virus, whereas the Western world is just being, you know, ravaged by wave after wave. So it's a complex, you know, equation, and I don't think any of us know how to balance it optimally.
I know Rosalind has a comment she'd like to make. Rosalind?
Yeah, so I wanted to, again, Holly was great to have that mention, and you're right, we could take a long time on China, absolutely. Just, I think, to summarize for the audience, maybe how would we summarize the Chinese view, or Chinese government view, if you will, to the internet compared to a Western view? The Western view, in many respects, we still have a notion of an open internet where there's we can use the internet for political action, to organize, to express, to connect with people. The Chinese government view would be the opposite of that. The internet exists to prevent collective action from the people. You could certainly promote collective action of the government. But I would say, as a person who studies China quite a bit, it is very difficult to verify the authenticity of Chinese reports about COVID. I think Taiwan is probably leading example. South Korea, we can actually verify those cases. It's very difficult to, for researchers to go into China and see how people have actually been treated. But I want to make a small point about the user perspective with regard to privacy regulation. We have a lab at Aalborg University where we do user studies. It's an important part of our work in the engineering field. And one of the assumptions of the GDPR with this idea of command and control, I, the user, would control my information. This assumes that maybe every user is a super user. It's like an IT nerd. I'm going to take my data portability and go from place to place. If you think about maybe your typical use of going online, you may visit 1,000 websites a day. It actually asks a lot of a person how much you're going to control your data, do you take it, and so on. And that what the GDPR is doing is it says, we assume there's one way that should be done. It limits, for example, let's say I, as a user, may say, well, look, it's not so important to me to have those things. Every time I go to a website, I have things pop-ups that are required by law. If I'm on a phone, it uses my data, it wears down my battery, it creates other challenges for me as a user that are not maybe to improve my online experience. And these are some of the things that we grapple with, when we want to make technology user-friendly. We want people to use the internet, to use apps and so forth. So I just want to have people to have in mind, there's other disciplines that look at the regulation and how it actually applies. And one thing that we have forgotten, or policymakers have forgotten, is the whole role of user education. Really, this is something that lacks in all privacy policies, is it respects what's the role of companies to work with their consumers, how people might learn at the school, how they might learn at their own, what stage of their life, how they can learn to do these things, and people can evolve in their privacy practices. So the challenge with a lot of the rules that we have is they're not very adaptive or flexible for people who are going to use the internet in different ways. And they're, those who want to take all their data and go from one place to the other. I will tell you, data portability, it sounds great, but it doesn't work in all cases. Your Facebook data is not something you can necessarily plug into Twitter. Even though all the large companies have done amazing things to make their data portable, that has been a huge investment and a huge cost to do it, but meaning that those resources were not necessarily spent on other things. It wasn't necessarily what consumers said that they really wanted. It is what the regulators believed that the market needed.
So I think that this is actually a great time to transition. So, Gabe brought up some really interesting concepts, and what Rosalind was just talking about, I think Olivier is going to have a pretty interesting stance on. And so let's get into Olivier. Olivier, tell us a little bit about the work that you're doing at Forbes.
Thank you, Brian, and thanks to the Center for having me. I've been having a lot of fun listening to everyone talk, and I like this format. My work recognizes the great promise of the network information economy, but I complicate it insofar as I try to think about the impacts that the distribution of user data has on historically marginalized groups, but consumers generally. And I've written about a kind of fetish, and maybe too strong a word, but a kind of fascination with innovation and what I've called elsewhere the trickle-down theory of innovation that presumes that there's something about the native capacity for companies to discern their consumers' interests. And I think it probably is a good segue from what Rosalind was saying, because I do think there are remarkable inventions and creations and ideas that have come out of the most popular tech companies these days, but there is insufficient attention to ad tech, which is something Omer mentioned. In fact, there's very little regulation of that, and that's the sort of thing that I'm most interested in.
So on what resources in law, technology, or anything else should consumers draw to protect themselves against automated decision-making systems that, without the intention of their developers, differentiate consumers on the basis of race, gender, age, or other protected categories.
Right. So this is the stuff I write about, and I do want to note that this event has been couched as focusing on Wisconsinites, and I was thinking, wow, I can talk about consumers in the United States and around the world. I don't know if I'll be able to speak about Wisconsinites. I'm relieved to hear that we're thinking beyond them, but I do want to note that there is a question addressed to a specific Wisconsin sort of issue that I can't answer in the Q&A. On your question, right? So the important aspect of the network information economy that makes it distinctive is the use of automated decision-making systems, very sophisticated systems that enable recommendations. I mean, most of us live by their recommendations. Spotify is one of my favorite apps because they really, for the most part, seem to figure me out. By every Monday, I very much look forward to their Discovery Weekly, where I get to see what songs they think I'm going to like. But on top of recommendations are a whole set of other predictive analytics that steer consumers in ways that are not discernible by regulators because they're one-off transactions with individual consumers. And in many ways, even when, as you put it, the designers of these automated systems for recommendations and others don't think that they are entrenching dimensions that are protected under the law, like race, gender, age. The algorithms tend to discover salient categories for advertisers, and for better or worse, those are the ones that prevail. So the one historically, and this is not new, by the way, right? So almost a decade ago, some of you may remember the outcry with regards to stories about the ways in which Orbitz or other companies were discriminating distribution of advertisements or posts about travel information, having price discrimination between Mac users and everyone else, because Mac users tended to have more disposable income, on the theory that they had more disposable income. That's old news, right? And by the way, price discrimination in our country is for the most part okay, but it is unseemly, and in some cases illegal. That instance, not necessarily. Fast forward to just a couple of years ago, stories about how Netflix was using artwork personalization. That is to say that for the same movie, the 6 of us who are on this panel right now might see a different advertisement based on a different still in the movie, based on our viewing habits, where we live, on a whole set of characteristics that could very well be proxies for race when combined together. And indeed, characters who are not featured but are people of color, Taye Diggs, for example, in Set It Up, right, is featured, even though he's a supporting cast member, on the view that African Americans would be likelier to watch the movie. Now, this too is not illegal, right? And in many ways, it's actually a tested marketing technique that has been applied across industries for a long time. Although for some people unseemly. That's why the stuff came out and reporting was done on it, and Netflix had a ready response. The challenge for me is when these categories are recreated and projected by predictive analytics and other automated decision-making systems in categories where that kind of discrimination is illegal, right? So in finance markets, in housing, in education, and in employment, and where there are disparate impacts. And that's the kind of area that I focus on. By the way, there are many of us who are writing in this space, people talking about hiring and employment, surveillance in the context of facial recognition, consumer finance, and the delivery of public health and disability benefits.
Do you, Olivier, think current laws and regulations are enough that we've got put in place?
No. I don't know if there are any laws addressed in the same way. So Rosalind very helpfully mapped out the difference between the sectoral approach in the US versus this kind of dignitary comprehensive approach, or what she called top-down approach in Europe. And even in the sectoral approach in the US, we don't really have any mechanism in law that's addressed to the use of user data in ad markets. Now, we have laws addressed to advertising, but very little in this context. And what's more, it's very hard to get that information. Gabe was suggesting something about a remedy that India is thinking about, which I find fascinating, and that is requiring companies to provide anonymized information, aggregated, I assume, about what's happening with the user data that they use. I'm intrigued by that. Many people are in this country, and you don't have to look much further than the political campaign of this past year with regards to political advertisements. People raising questions about how user data is being used to target ads or just content that is false or misleading. So we don't have ready mechanisms under law, but there are things that we do, that the policymakers and courts have done that actually even make it hard for us to make that discovery. And what I've written a lot about is the Communications Decency Act, which creates effectively a blanket immunity for any lawsuits brought against intermediaries that purport to be hosts of third-party user information like Facebook or Twitter and a whole set of other companies, and claim that they're really just kind of neutral platforms, and are able to do that and avoid any liability for perpetuating harms, the kind of harms I'm describing, under the statute. And we can talk more about that. There are kind of technical elements to the doctrine, but I think these days it's in the air enough because our president was talking about it in a different context over the summer. I do think that there's an opportunity for that law to be reformed in ways that are attentive to the possibility of bringing lawsuits against intermediaries that do traffic in user data, and finding out as a matter of discovery whether or not they are implicated in the way in which that data is used. A case that I was involved in as a consultant there were 5 cases brought against Facebook in 2017 and 2018 for the ways in which its ad manager enabled brokers, housing brokers, and homeowners to discriminate between different kinds of users, actually promote their housing based on characteristics that are forbidden under the civil rights statutes, like race and age and gender. And what Facebook said is that its automated decision-making systems generated these categories. As you know, if you have a Facebook account, you don't volunteer that information. Conspicuously, they don't ask for that information, but yet they were able to create these categories based on your networks, your browsing behavior, and it tended to be accurate. That is to say that it could be pretty predictive of your race or the network in which you hang out. Facebook purported to revise this. They actually entered a settlement in March 2019 in which they said they would not allow the use of these categories in housing, finance, and education. But further research by journalists through 2019 revealed that they continue to. And it's largely for the reason I've given. Even the developers of these automated decision-making systems do not themselves know what patterns these systems will discover, right? So age remained a category that advertisers could discriminate on the basis of. And by the way, this continued well into this past summer.
So thank you, Olivier. It's such an interesting perspective. Does any of our panelists have any questions?
I wondered if I could respond to some of that. Thank you. I thought that was really interesting. I did want to respond to the notion of there not being any law. And I think that is largely true in some domains. But I wanted to point to, for the listeners out there, some of the provisions of GDPR that have sought to address this, including, most notably, there's a right under GDPR not to be subject to solely automated decisions that have legal or similarly significant effects for individuals. And what counts as a similarly significant effect is, of course, a subject of debate. But regulators have said that advertising on the basis of sensitive classifications could rise to that. And if it is an automated decision, then the GDPR requires consent before that decision can be taken. And it gives rights to challenge the decision and contest it, and requires of the decision maker that they implement appropriate processes to root out discrimination and bias. Now, the GDPR has a lot of other rights in it that are, I would say, lower hanging fruit that regulators have focused on. So there are more basic elemental provisions that regulators have been spending more of their time trying to get people to come up to standard on. But the existence of that right has driven the way organizations, especially more sophisticated organizations, are thinking about these issues. And it's very much on their radar and something they're working on. I think you highlighted the challenge between the power of some of these predictive tools, but also the risks that come with it, in that they can reflect biased data and reflect bias in the creation of the algorithms, and really are just correlations and not always intentional or reflective of our best aspirations. So I think it's a phenomenally complicated area where people are working to solve the problem, and there is some law, but you know, I think we're not quite there yet.
Can I
Oh, please.
respond to this? So I'm glad Gabe mentioned the GDPR as a point of contrast, because we have no such law in the United States, right? So the closest we have is the CCPA and the CPRA that you talked about. And I'd love to know what the mechanisms under that statute that might resemble what you just described. As I understand it, there isn't, but maybe I'm wrong about that, and I'd like to be wrong about that. I want to say something more about this, though. It isn't just that there's an absence of that kind of protection in the United States. There is, you know, I hesitate to say fetish, but I still use the word, but a kind of a deep ideology that presumes that to the extent we create safe harbors and innovate for innovators, that they will be attentive in the way that Gabe, I think, hosts to consumer protection. But I just to be clear, this is a thing that continues to proliferate. Just this past year, the HUD, the Housing and Urban Development Agency, proposed a rule that would create another safe harbor for brokers that use automated decision-making systems, and would allow them to use it as long as they certified that race or proxies for race and other protected categories were not being used as input data. What the proposed rule didn't notice is something that's basic, even to me, who's not a technologist, but for many people who study this space, is that, as I said before, automated decision-making systems discover patterns that are salient, and in housing markets, race is. This is not just, Gabe, this is not just in my mind replicating what is extant in society, but entrenching it and potentially making it worse. Fortunately, HUD decided not to pursue that rule in my mind.
I think you're absolutely right, 100% right. And I think, you know, I do think there is a need for privacy law to address these issues here in the US. I think organizations in the US, even in the absence of a comprehensive law, are thinking about these risks because, one, a lot of them have global compliance processes. So what they do for GDPR ends up trickling down elsewhere. And two, to the extent this becomes a global standard, and we are seeing other laws around the world, Canada just 2 days ago is proposing something very similar, then there is liability, there's potential for liability in the US under just negligence standards, to the extent this becomes viewed as what is reasonable and required not to be negligent. So it is complicated. I think you're right to point to the absence here, but I do think that organizations are working to address it, and there are incentives for them to do so.
And I think that this is a good point for us to move on to our next panelist, Omer, because I have a feeling that you're going to have a lot of thoughts about this as well. And so before we dive into that, can you tell us a little bit about your work at IAPP?
Let me suggest this, Brian. Let me just tie a bow around this last discussion, and then we can, because I just wanted to quickly react. I take the point from both Olivier and Gabe that GDPR does have, you know, rules about automated decision making, and in the US that they're not present. But I do want to point out that they are present in the policy discussion in the US. And specifically in the US Senate, there has been language bouncing around in a couple of pretty well-developed bills from both sides of the aisle, from Republican leadership in the Commerce Committee, Senator Wicker, who's the chairman, and from Democratic leadership, Senator Cantwell, who's the ranking member in the Commerce Committee. Comprehensive privacy laws that also include a lot of language about algorithmic accountability, transparency, fairness, and equity. So while these issues have not yet been reflected in US legislation, and this, to the advocates' dismay, does include CCPA and CPRA. In fact, some advocacy groups opposed CPRA in California precisely because of the absence of these provisions. They are reflected in the discussion, the highest level of policymaking in the Senate. And I do expect these bills to converge during the next Congress and hopefully also pass. And I'll say, regardless of whether, of which way the two runoff elections go in Georgia, I think even with Republican majority in Congress, in Senate, sorry, I think we should see these bills advancing with language about algorithmic fairness and equity. Full stop. Now to answer your question. So the IPP, the International Association of Privacy Professionals, is a professional association for people who work in this space. We are a membership association. We have more than 60,000 members all over the world. It is international. That's our I. The US is our largest single country jurisdiction, but Europe is, a close second and growing very rapidly, as Rosalind suggested, significantly since the passage of GDPR. We are a nonprofit and also non-policy because we have members from the entire ecosystem. We have people from government and from the private sector, from national security agencies, and from tech firms and banks and healthcare. We have regulators and academics. So we don't take policy positions. But we do provide training and certification. We used to have events, now they're virtual, but hopefully at some point they come back. What else? What am I forgetting? We have publications, we have research. So we really do what a professional association does. My role, I'm the chief knowledge officer, which doesn't mean much to anyone. It's one of those titles, but I'm responsible for our publications, research teams, programming for events, or the content for events, and also communications and external affairs.
So, Omer, you've actually mentioned the pandemic earlier, and there's a question that definitely I want to ask. How did privacy data protection change since the pandemic?
That's a great question. And, taking a step back in the privacy world, which, the people here in this panel are part of, it's been just a constant, really dizzying flurry of activity for a few years now. And not a week goes by, sometimes not a day goes by, without new developments in privacy policy, technologies here in the US and around the world. We thought initially when COVID-19 hit that, there are more important things in the world now, and people will focus on, public health and the economic carnage, and maybe privacy will be left aside. But in fact, what we've seen is that the pandemic and the pandemic response have just elevated privacy even more and really surfaced a lot of issues that weren't front and center, but now are. And our pace of activities and, it has just become even more cutthroat. So I'll give you some examples. The massive transition to working from home and learning from home. It turned on a dime, and I remember the day, March 16th, we were still in the office working, and the next day it was over. And I have 3 kids in the house who are learning from home. I work from home, so I don't go to an office. And of course, these activities involve technology platforms and just a constant stream of data. So in my case, it might be more corporate business type information. But if you think of my kids, our kids, right? It's pretty sensitive. It's information about kids. They're learning. They're just, video footage. So obviously this elevated questions, issues about protecting data security and privacy in platforms such as the one we are on right now, Zoom and its competitors, and also a lot of the education technology platforms that kids and students in higher education too are using day in, day out and all over the world. That just, a degree of prevalence and sort of depth of integration that we couldn't even conceive of just a year ago.
So Omer, thinking about into the future, so I know right now we're, everybody's really focused around the concepts around COVID and the pandemic, but, we do have a new administration coming. What changes to privacy and data protection do you see in the upcoming Biden administration?
Yeah, so, again, this is one of those big questions that we could devote an entire panel to. And I will say that at the IPP, we have actually had the panel on this just last week after the results were made public. This is a multifaceted issue, of course. I talked, just a couple of minutes ago about the prospects for federal privacy legislation. The drafts that we've seen from Senate Republicans and Democrats are pretty similar on a lot of the privacy issues, but there are a couple of obstacles. The 2 main ones don't even have much to do with privacy. They're more kind of procedural or meta privacy issues, namely the existence of a private right of action for individuals to be able to enforce the law, and the degree of preemption of state laws. Those are the divisive issues between Senate Democrats and Senate Republicans. And I think a Biden administration, if it decides to make this an issue that it wants to try to advance and pursue, and I think it should, because it is a bipartisan issue that isn't, overly politically divisive. So it's I wouldn't say it's low-hanging fruit, but it's, it's fruit that one can reach. Then that might actually seal the deal. So, I think if a Biden administration pushes hard for privacy legislation, it could happen within the next Congress or the next 4 years. Another issue is the Federal Trade Commission, its budget, its powers, and how forceful it'll be as a regulator in this space. That depends to a great degree on the administration, because the convention is that the president's party has 3 out of the 5 FTC commissioners, including the chair, and I think it's likely that this will be the case in the next 4 years also. What will a new FTC do? Will it obtain additional funding? These are important questions. One kind of new variable here is that the CPRA, California's new privacy law, establishes a new privacy protection authority. So you will have some competition between privacy regulators in Sacramento or wherever this California privacy regulator will be set up, and the FTC in Washington. I think some of the techlash, the regulatory reaction to the power of technology companies does cross the aisle. So in the past, the Obama administration was considered to be very close to some of the leading technology companies, Google and others. Under Trump, of course, it was a different situation. I don't expect to see the Biden administration kind of follow closely on the Obama administration's footsteps in this regard. I think there is a lot of conviction among Democrats too that some of the largest technology companies need to be more regulated on antitrust, on privacy, and on content moderation. So these are some of the issues I think to watch for the next couple of years.
Interesting. And so in respect of time, I'm going to go ahead and move on to Holly because we're moving into that 30 minutes left on our window. So Holly, being a fellow Wisconsinite, tell us a little bit about the work you're doing at UW Stout.
Thank you, Brian. So when I think of my work, I think there are 3 components. First, I'm a professor, so I teach. I think that's the most important part of my work. Also, I'm a program director of a computer network information technology. So I advise students, safeguard the program plan, build a connection with our industry partners, ensure the students get the right skill set, so they can get a job. I'm also the center director of a cybersecurity research center. So I research, outreach to the communities. So UW Stout is the first 4-year university in the state of Wisconsin till today, the only 4-year university in UW system received designation from NSA and Homeland Security as a Center of Academic Excellency in Cyber Defense Education since 2017. So that means a lot. As today we talk about the privacy and the security, I want to say my job or my students' work is more focused on about security measures taken to protect the data and safeguard the data, and therefore to protect the privacy. So we are more on the technical side, I would say. So when I think of myself and my students as a computer networking engineer, traditionally we focus about sharing the data and then moving the data from point A to point B as fast as we can by using different networking protocols, OSPF, ERGRP. Think about the network that was first originated back in the 70s. We started with a sneaker net. You want to share the data with your friends, you put on a good pair of a sneaker, you carry the floppy disk, you run from one computer to another computer. So that's where the network started, sneaker net. Then we move on to the ARPANET, then Ethernet. Nowadays, we move on to the Wi-Fi 6 and the 5G, and the fiber. So while we're moving the data and sharing the data, later we have a malware, virus, worms, DOS attack, DDoS attack. Data may be stolen, modified, unavailable. So now we need to focus on protecting the data. So we need to secure the data with VPN, firewall, AAA, all those technology we teach in our school to make sure data is CIA called a confidentiality, integrity, availability. That's 3 pillars of the security. So that's what I'm doing and what my students doing. I know I have quite a few students today attending this panel. I feel so proud of them. So we are network engineers. We are security engineers. We share the data, but building the network infrastructure at the same time, we safeguard the data to protect the privacy. We also do security assessment, to make sure that network infrastructure we build meet HIPAA or PCI compliance. So that's part of my work is teaching and advising students. As a researcher, I want to talk a little bit about the recent project that I'm working with my students and my peers, at UW South. So we recently got funded from DoD a research project about secure smart manufacturing with Industry 4.0 and 5G and Wi-Fi 6. So as we know, manufacturing is not only the backbone of the US economy, but also the backbone of US military technical advantage. As the technology move on, this IoT, industry IoT, 5G, data analytics, security, machine learning, or artificial intelligence is impacting the future of growth of manufacturing. So the next generation of weapons require advanced software, artificial intelligence, machine learning. On the other hand, during the past few years, there are several EU-level initiatives. I don't know if you know that China Made in China 2025 initiative, getting people's attention actually a lot, trying to digitize and automate their manufacturing to preserve their competitiveness. So for a long time, when you think back, the cybersecurity had never been regarded as a characteristic rather than just a design principle in the industry control system. Vulnerabilities are often introduced to manufacturing systems through the poor security design, policies, and the practice. So, but connecting those machines together, smart machine sensors, PLC directly to the internet will significantly enlarge the potential attack surface area. So attackers or hackers may use the same skill set in the field information security extended to this industry control system. And believe or not, actually, you probably don't know that most common route to carrying out attacks on this manufacturing system actually by installing malware. There's a couple of incidents that happened during the past few years. In Ukraine, Germany steel companies causing like 2 million people lost their power, just because of this malware or social engineering attack. So in our proposal, in our grant, we propose to use a segmentation and a defense in-depth strategy in our security design. So the security architecture will include DMZ zone to segment the enterprise network from those industry network and segment different industry network from each other. So we can rapidly quarantine the rogue device if there's a breach or other anomaly is detected. So we are using segmentation strategy. We also use the defense in-depth approach, including secure boot, authentications. Another part of our research is focused on the 5G. We just talk about how the network evolved from SneakerNet, ARPANET, Ethernet. Now we move on to the 5G. 5G is I know it's a buzzword, but 5G is incredibly valuable in providing value into many industry verticals. Why? Because it's provide massive machine type communications and ultra reliable low latency communications. So however, we say that 5G is a buzzword because why? Because few 5G IoT devices exist today. So we can wait, but we don't need to wait. Before the 5G hardware device become valuable, the market does not need to wait. So we're looking for the alternative solutions. The alternative solution we come up with, me and my students, my peers come up with, by using the Open LoRaWAN protocol. Open LoRaWAN is a low power wide area network technologies. It's using unlicensed sub 1 gigahertz industry scientific and medical ISM bands. So we also consider other solutions in our research. Wi-Fi 6, Wi-Fi 6 is getting really big. Zigbee, RFID, Z-Wave. So each have its own unique set of features and requirements. So that's the current one of the research, me and my students are working on this project. So another part of the project I'm doing is relating to workforce development. So we help students get into the cybersecurity workforce, not just go to the private sector or business. We want the students to go to work for federal agency. to protect the nation's network infrastructure. So that's part of my job is to help students get a scholarship from Department of Defense, cybersecurity scholarship. It's one of the most generous scholarship in the world. We have students 3 years in a row getting scholarship from this DoD cybersecurity program. They have scholarship cover all their tuitions, $25,000 stipends, is laptop, free trip to attending conference. Then they get a paid internship from NSA, and then they get a job from NSA. I have a couple of students, especially on the stress out, most of them are female students. They work for NSA in Washington, DC, and other different locations. So that's a part of my work. So I think that's all I want to say.
Yeah, and all of the work that you guys are doing at UW South is always intriguing to us, just our colleagues right down the road that we get to hear so much from. So we really are running low on time, and I definitely want to make sure that our audience has opportunities to ask questions. So I'm going to go ahead and open it up to some Q&A. I see we've already got a couple of questions being asked. The first one is, did Wisconsin have a state privacy officer? I am not 100% sure on this. I know that Trina Zenow is our new CIO. Holly, do you know if we have a state privacy officer in Wisconsin? I know we've got somebody dedicated to just HIPAA. Are you familiar with that position?
I just have a talk with Dr. Roger, a couple of days ago. I think is that Bill?
Bill Nash, maybe?
Yeah.
It potentially might be Bill Nash.
Yeah.
I think Roger is if Roger could text me the answer to that, he can let me know. This next question might actually be for Rosalind or maybe some of the other panelists. What is the status of freedom of information legislation in Europe and elsewhere?
That's a great question. I don't know for sure. I do what I would say in my own experience, it does vary in the country. I know in the Nordic countries, we have exceedingly open, or how would you say, you can get a tremendous amount of information from the government. Their emails you have access to, their spending when they go on trips. That is the Nordic countries. I don't know if that's the same across the EU. That is a great question, though.
Any of our other panelists have want to chime in on that?
I can speak to the UK and just echo that freedom of information laws in the UK are quite similar to those here in the US. If the question is about freedom of speech more generally, then there are some notable differences between Europe and the US, but freedom of speech is also quite protected. Sorry, Olivier.
No need to apologize. I wasn't going to speak to freedom of information, just throw out the other possibility that people look into. Maybe Rosalind, you can speak to open data efforts in Europe, which are actually the sorts of things that are happening across the world, and the sort of thing people are talking about. So I know that there's an open data initiative, or is it called an EU open data portal, or something like that, through which anybody can gain access to data sets. And I'm sure people like Holly love access to data like that.
Well, I'll just say one thing that on that, certainly the EU has an open data initiative that is particularly to get government information in the public, for researchers, for entrepreneurs. I think it's extremely valuable. One of the areas where there's been a challenge with GDPR would be on the WHOIS database, the Internet Registry. This has become quite a problem for law enforcement, where normally in the past, they could access the domain registrar, domain information for when they were pursuing, let's say, child abuse cases, human trafficking, terrorism, and so forth. This was also been used by trademark owners and so forth. That has the WHOIS registry now, it wasn't required in GDPR, but they have masked that data, which used to be freely available. So this is one of the, I would say, a downside of a GDPR at this time. Has not been resolved. But again, it's maybe a contradiction where we want to have open data, and then databases that used to be open are not so open anymore. But I think these are, this is a global world we live in, and information flows, which we assumed used to be so free and free flowing, they're not necessarily. And we have conflicts and clashes in our different regimes.
Actually, we have a question now for Holly. Holly, could you say something about the concept of social credit in China and its implications for citizen privacy?
Well, that's something actually, when I first heard about it, from one of my colleagues, actually, I don't believe it actually. So social credit, if that's what you talk about, they give you the credit based on, if you go out to buy the milk, okay, they give you credit because they think you are a family man, is that what you're talking about? Social credit?
Yeah, I'm not really sure. It was a question from the audience.
It's referring to the social. It's a reputation and financial system that is operated in China. Now, in the U.S., we have Equifax, Experian. We have different financial credit rating systems that are run by the private sector. But the social credit system is run by China with the idea of giving people scores and companies based upon their financial and social reputation. I think it's quite controversial. Any Chinese company must give a feed of their customer information into that system. Now the concern is that Americans who would use Chinese apps, TikTok, and for example, would also be, presumably their information would be going into the social credit system. And it is quite actioned by the Chinese government. If, for example, you might not be able to buy airline ticket, you might jaywalk in the street, you get deducted on your social credit system. And so not even having to go to a trial or something like that, you are blocked from, going on an airplane, eating in a restaurant, what have you. So this is, quite an interesting use of technology and certainly controversial one.
Thank you. We do have a question. To what degree do colleges and universities have a responsibility to provide instruction for IT students on broader policy issues? Is there enough to gain from devoting degree time on policy at the expense of technical skill development? I'll actually take a stab at this one just from my perspective, where at my university, we're very focused on IT and cybersecurity instruction. We do understand that there are so many privacy concepts that are really being pushed out. People are going to need to understand the laws that exist. And so I can't speak directly about what curriculum we're developing, but any curriculum in the future is going to have to be included what laws they're going to be expected to follow when they get into their careers of choice. Would anybody else like to expand on that?
One thing I know that has emerged, I'm not a technologist, as I said before, but one thing that I know has emerged is an attention to ethics apart from law. And a lot of communications programs, communication technologies programs have invested a lot of energy in hiring faculty and researchers in the areas of ethics. And for what it's worth, this speaks to things I think everybody on this panel has talked about. And I know that Omer has thought about, and that is this notion of privacy by design, that there are standards that technologists themselves are thinking a lot about baking into the software and systems that they develop. People like me tend to think they're too slow, but in any case, those efforts do exist. And I think it's incumbent on schools, as you suggest, Brian, to focus on laws, but also on ethics.
Yeah, if I can just add, Brian, that I think this is a key, crucial point for developing the professionals of the future. It's no longer enough to have just the zeros and ones or just the liberal arts. You really need a combination, especially in a field like privacy, which is hard to articulate in equations, but requires softer skills and for, like Olivier said, what we call privacy by design or privacy engineering. It's really critical to understand some of these softer concepts, which aren't just law. It goes far beyond law and even beyond ethics. It's really, social sciences and philosophy and kind of constructs from the liberal arts.
Going on to our next question from Bruce. Does having one state, specifically California, create a privacy policy, induce companies to implement changes and globally add them to add customers? GDPR made us make information retention the same across all of our customers worldwide concept. Gabe, what are your thoughts on that?
Yeah, I think we're seeing a range of different approaches from different companies. I would say most US companies that are operating nationally are extending some elements of CCPA nationally as well, or internationally, just because their systems aren't always segmented in a way that would allow them to distinguish. But we are seeing different approaches. It really does depend on the type of company and the way they're set up.
Are we seeing any other states looking at putting something together like California?
Yeah, absolutely. There have been a lot of state initiatives, and I'm sure Omer can speak to them as well. Probably the front runner is Washington State, which is, again, for the third year in a row, proposing a quite comprehensive privacy bill that looks a lot like the GDPR. And there seems to be a fair amount of momentum behind that initiative.
Just maybe to add, Brian, that California isn't just another state, of course. It's, you know, standing alone, California is the world's fifth largest economy. And not only is it a major part of the US economy, it's also home to the tech industry. So I think California's law definitely, you know, becomes a de facto national standard. We've seen it in other contexts, kind of on the periphery and privacy with security breach notification, with privacy policies, but also in completely different areas like environmental protection and others. But having said that, yes, other states are following suit. Illinois, for example, your neighbor, has had a very specific and strict biometric privacy law. Wisconsin itself has laws around breach notification, about protection of telecom data and others. And all this, you know, this quilt work, patchwork of different state laws is one of the main drivers for federal privacy law to harmonize the space. And it's the reason that industry, which for many years opposed federal privacy law, has now for the past couple of years strongly lobbied for a national standard.
Okay, our last question is definitely a thinker, and so I think it's a good one to end on. Noah asks, watching different hearings regarding privacy and security on Capitol Hill, it seems that there are many different levels of understanding among lawmakers on the many facets of the modern privacy cybersecurity ecosystem. I think we can all agree to that. What efforts are being made or need to be made to ensure lawmakers are making the most favorable decisions with the most knowledge for the privacy security rights of the American people?
I think, you know, the hearings that one views on C-SPAN or you know, the news networks can be a little misleading, because while, you know, the folks on the Hill might seem not fully up to speed on some of these issues, and to be clear, these are very technical issues sometimes, and you can't expect, you know, lawmakers to be experts on anything and everything. But I think staffers are very sophisticated. And I do think when you look at the outcome, at least in the privacy space, when you look at the bills that are circulating around, they are highly, you know, sophisticated, advanced, kind of on a global stage. So I kind of hear what Noah is asking, I think, because when you watch it on TV, sometimes it seems underwhelming. But I do think there's enough expertise on the Hill to develop and deliver a good, you know, legislative outcome.
Rosalind, did you want to weigh in?
I wanted to say that we, you know, the Uniform Law Commission, it's a parallel process to what's going on in Congress. It is it's a nonprofit organization that with two commissioners from each state and hundreds of observers and participants, it has been working on online privacy law in an attempt to harmonize the different state laws. It has tremendous amount of expertise from every facet of America's digital economy, or all of the parts of economy. Everyone uses information now. And they work through the issues in a deep way. In fact, we had planned to meet in Wisconsin here in July for the conference. Unfortunately, was canceled. It is. I would just to have, if those are interested, you can go online to that, and even Congress itself. For students who want to study this, it is a tremendous policy education and exercise. Federal Trade Commission has done this, many regulatory agencies. You can review for yourself all of the proceedings, the testimony, the attachments, the analyses. It's not something that we have so much in the European Union. There is not the same kind of policy because of many languages, of course, but it isn't organized in the same way as the US, where there's really a tremendous amount of public involvement, expert involvement. It's posted, you can review it, you can study, you can debate it. The proceedings are made public. So what I will tell you is whatever privacy law we do get, it will be extremely informed. I would certainly echo what Omer is saying, and over a long period of time.
Olivier, I'd love to hear your take.
Yeah, so a couple things. I think I'm going to amplify points that Omer and Rosalind have made, and maybe add one more. And I mean, there are policy professionals like Omer and Gabe who are on the Hill, who are in DC working with, maybe not with legislators, but with groups that are actively involved in the drafting process. So, I teach a course called administrative law, and in the law school, and part of the things we talk about are the ways in which laws get written. It isn't just the legislators, right? Will also be, as Rosalind was suggesting, the policy officials that work at the Federal Trade Commission, the Federal Communications Commission, or HUD or the SEC, and they are staffed with people who are actually quite familiar with extant technologies. I say that because the stuff that's in the air won't necessarily just get articulated in legislation. It could be done by the FTC, and an FTC under the Biden administration, I suspect, would likely be far more adventurous in this space than under Trump administration's FTC.
So we are at 1:58. I want to be respectful of everyone's time. So a huge thank you today to our panelists. I think the conversation was great. I love the back and forth, and I think that we got a lot out of it. Rosalind, Olivier, Gabe, Omer, and Holly, thank you very much. Thanks to our speakers and for all of the insights that we got today. I'm actually going to turn it back over to Eric to give us some Thompson Center updates.
Very good. Thank you so much, Brian, for moderating today. And I wanted to thank our co-sponsors again, the Jean Monnet Grants at UW-Madison. We have Elizabeth with us here today. Brian, again, thank you from UW-Whitewater's Cybersecurity for Business. And UW-Whitewater's CyRock. Holly, thank you so much for serving on the panel today. And then I just wanted to give a thank you as well to Olivier, Gabe, Omer, and Rosalind for giving so much of their time today and sharing their expertise with us. Privacy and security in the digital world are extremely complex, but they have a true impact on each one of us, as well as our economy moving forward. So it's a really fascinating discussion. I think, the state level Uniform Law Commission, federal, and then the other countries that are working in this space, I think, are really doing a lot of interesting work. I think they're discovering new ways of looking at this topic, and the evolution is going to be fascinating as we move forward. So I want to thank everyone again. We have an event coming up here at the Thompson Center on Wednesday, December 2nd at 7 p.m. We will have Kay Coles James from the Heritage Foundation joining us to share a little bit about America's pursuit of equality and civil rights in this day and age, which are very timely issues. So we encourage you to tune in then. And in the meantime, thank you for joining us today, to everyone in the audience. Take care.